All right, Stanislav, thank you for your analysis. Thank you for your strategy. You're giving me 90% plus of approval rate. But what's gonna happen if we get a denial? I love this question, guys, because this is the best question that you may ask, because that means that you are thinking about your future and this type of clients I wanna work with. So today I'm gonna explain what a denial means, what are the ways fighting the denial, and how exactly we are doing here in my company. So stay tuned, let's go. Hello, my dear friends, I'm Stanislav Shamayev, a licensed business immigration and corporate attorney in Miami, Florida. We are going to discuss all the ways, the appellate level of fighting the denials, the federal courts, the motions to reopen, the refiling of the cases, and things like that. At the end of this video, you will be able to learn how to get a free evaluation of your talent cases, national interest waiver cases, and business and investment cases. So stay tuned till the end. This is one of the most asked questions when we get to the level of the complex immigration planning. And that's the service that we offer in the company, where I build a written strategy of your case. And it happens in two phases. The phase number one, you meet with the data manager who gets and collects all the information about you. And the second phase, when you meet with me and I already have the written strategy for your case and we discuss it. That's great. And usually I say to the clients who satisfy the criteria that I want to see in the case, that provided that you fulfill the strategy that I provided for you, you will get approval with anywhere between 90 to 99% chance for the petition, okay, depending on the visa. So, but what if that 1 to 10% plays out and we get a denial? And that's what we're going to be talking about. Now, guys, very important to understand. You never get the denial right off the bat. It doesn't work that way, that we file the case to the USCIS and bam, we get a denial. Never happens like this. First thing first, you will get the RFE, request for evidence. In RFE, the immigration officer is going to tell you, hey, I don't like this, please provide me more documents here. This is insufficient, please show me how you prove this criterion, and things like that. So basically, he will say what you already satisfied and what you did not satisfy and request more evidence. And there is no problem. Every time we get an RFE, and by the way, we get those RFE very rarely, especially recently, because we've built the processes in our company that way that we file your case and we get an approval with very high chances, okay? Very high chances, because you have the team working for your case. There's like at least 5 people who are attached to your case, and total 12 people in the company who work with you from the beginning till the end. That brings a lot of result, okay? And we're very result oriented. But that happens. That happens for many reasons. Sometimes the officer did not see some proof in the case. Sometimes the officer missed the critical information. Sometimes officer thought subjectively that what we provided is not enough. So there are different reasons why this may happen. However, because I've been practicing almost 10 years in my company and a lot more years in American jurisprudence, we analyzed all RFEs for all these long years. And we created the black lists of the immigration officers. And you'll be like, Stanislav, can you post them online? Of course not. This is a commercial secret. Okay? This is not going anywhere near posting it online. You guys get the benefit of that blacklist when you're working with my corporation. How does it practically work? And we have the lists, and they are compiled from the worst officer to the best. And of course, for the years of practice, we know all these officers. Once in a while we'll get a new person, but that just means there's some type of rotation. But most of the officers are just working there, and we know him pretty well. Number thing I do when I get an RFE is look who is the officer. And if that officer is from top, depending on the center, if it's Texas, if it's Nebraska, if it's immigrant, non-immigrant visa, I look top 3, top 5. If I see that that person, and it's like a number, Officer X3520, there's no name, there's just a number, but it's always the same number for the same person. So we'll look if they're top 5 from the top of the blacklist, and if they are, we reread the RFE looking for determination of the tone of that RFE. Sometimes you can clearly see that the officer made the decision. Yes, it's illegal. Yes, they cannot do this because they can make the final decision only after the answer to RFE. But you can read between the lines, okay? And if it's the case, look, you don't want to deal with this. Neither we nor you, no officer, nobody already wants to deal with this anymore. So my best recommendation would be to withdraw the case and refile it. Okay, maybe tweak certain things, maybe change things around. Because sometimes they put something reasonable in those RFEs. So this is the best way, and if you work with me, guys, I'm not going to charge you a penny at this level to refile your case. Yes, you will have to pay the government fee again. That's the negative side, but hey, you'll get a fresh look at your case by a different officer with a much better chances of getting an approval. This is number one. If it's still the officer from the blacklist, but you can read between the lines that he really wants to get more information on that, then we're gonna respond to that RFE, okay, and get you the result with the good chances. What if it's an officer that we never met before, or it's just the officer that we know and he or she, they're reasonable and they requesting maybe we missed something. I mean, that doesn't really happen, but we're always critical to our own petitions, okay? We always look at it objectively and we're ready to admit if we missed something. Maybe we didn't miss it, but we didn't put it the way that more clear or more understandable. Okay, things happen, because we're all people, we're all humans. Soon we'll be robots doing your applications, and everything's going to be just the same way. But because we approach each application individually, I never do boilerplate application. I never do boilerplate petition, which is the same case by case. No, they're all different, they're all in different order, everything is different. Of course, that's great because they're authentic, but that also leaves a little space for maybe some mistake, okay, or some omission, let's put it this way, some omissions. No problem, we're gonna complete the case, bring more letters if we need to, show to the officer, which is almost always the case that they missed the information in the case. They big, guys, they're big. And the officer has what, like 2.5 hours to go through this huge pile of documents. So of course you're gonna miss things because this is just a lot. And especially if it's like a STEM case, like engineer or like IT person with some innovation, some crazy scientific stuff, you're gonna miss things, okay? So that means that we're just gonna reply and respond to the RFE and get an approval. Let me give you some statistics. For 2023, we got approximately about 10 to 15% RFEs to the filings, meaning that other filings got just approvals. 85-90% of them got an approval, and 10 to 15 we got an RFEs. Maybe about 25% of those RFEs we just refiled because they were the officers from the blacklist, and the tone of the RFE was just nasty. Like you could see it. The guy didn't like the case for whatever reason, Lord knows. Maybe he didn't drink his coffee in the morning. I don't know. I don't want to get into that, but for whatever reason. And the rest we were replying. So our rate of getting the approvals after RFE is very, very high. If we decide to answer, the approval rate is above 60-70% to those to the number of RFEs, which is really, really high because RFE is basically the first sign of a denial, right? Like that's the first step to deny the case. So if we get those potential denials to 60-70% of being approved, I mean, this is really good. Now, guys, your favorite thing, Stanislav. Good stuff. What about those that still get denied? You get the denials, right? Everybody gets the denials, guys. Everyone. There is no single attorney in the universe who never got a denial. And if an attorney tells you that I never got a denial for whatever that petition or visa, that means one out of two things. One, he filed maybe a few cases because first, like 6-7 years, I had 100% approval rate for O1 visa, but then we started getting like dozens and dozens and dozens, and within those dozens we got one denial. Okay, one denial, and 99%, maybe 99.9999 of approval for O1, which is pretty good. But that means it's a fresh attorney or a small amount of cases. Or number two, he's a liar. Okay? Because everybody gets denials once in a while, even the best attorneys. Even Ira Kurzban, the god of immigration, gets the denials. Okay? I've seen them with my eyes. And he's open about it too. If the attorney tells you that there's no denials in his cases, you may reconsider that attorney. You may reconsider working with another attorney. So, but what happens then? But before I proceed, guys, first of all, a like button. You love what Stanislav tells you about all this craziness in USCIS. And you love that Stanislav spending his Sunday sitting in his office doing this content for you. Okay, so you guys know what's going on. So smash that like button, subscribe to my YouTube channel, and smash the bell button not to miss the 2 videos that I release every week. Also, those of you who want to know your chances for talent visas, O1, EB1A, for national interest visas, EB2 and IW, and for business investment visas, L1, E2, EB5, you can get a free evaluation of your cases. Go down below this video, find the corresponding link to the proper visa that you're looking at. You may be looking at 2 visas or even more. Fill out those forms. 2 days, I'll get back to you with a free analysis. And then if I see the potential in your case, I will invite you to the complex immigration planning, and I will build a beautiful winning strategy for your case. What happens if we still get the denial? And this is the $1 million question, because we have a few options. Option number 1, file the motion for reconsideration or motion to reopen. They're very similar. I do believe that motion for reconsideration, and don't quote me on that because we don't do too many of them, you can file additional evidence. For motion to reopen, you cannot. So you just say, hey, just reopen my case and see what's happening there. But like I said, we don't do too many of them because I think that's an unusual way to get the approval. Immigration officer got his decision. You want to ask him to reconsider because maybe you saw a mistake, but the chances of getting the success at this point probably around 5%, my estimate. So I don't think you want to spend additional money and wait and be nervous to fight for 5%. I don't think this is the case. The second option is the AAO appeal. USCIS has different level of hierarchy, okay? So there is the immigration officers, and there is the second level of reconsideration, okay? That's the administrative appellate organization. What they do, they reconsider de novo, and de novo means like new. They don't consider the decision of the officer below. They like new freshly at your petition, and then they make a decision. Okay, like appellate decision on the same level of the agency of the USCIS, and the chances of getting appeal go through is probably around 15 to 20%. A little higher than motion to reconsider, motion to reopen, but still, I don't think you want to fight for this 15 to 20%. The third one is very effective, very effective. With a good case, you go straight to the federal court. And this is really serious stuff. It's going to be expensive. It's going to take probably another 6 months, but it's very effective, okay? I would really consider a federal court, especially if you got, let's say, 2 denials on a very good case that I think should be approved. I believe you should skip the administrative appeals on all these motions, just go straight to the federal court. It's gonna be good, especially if you have the budget. This is one of the best solutions. However, guys, I'm a firm believer that the best solution for all of you is to refile your case. Refiling of the case gets much more chances of getting approved. It's fast and it's going to be cheaper, because if you refile your case with my company after we got a denial, we're going to give you much better price. We're going to charge you maybe only 50% of the original contract. Let's say you paid $15,000 for your original petition. Now you have to pay only $7,500 plus the government fee to refile your case and get again more than 90% of approval rate chance. All right? Compare it to again, like 15,000 for the appeal, for the administrative appeal or for the federal court, okay? And the timing is like 6 months. So I believe 15,000 and 6 months of wait at least, and 7,500 and 2 weeks of wait. You do your math. I'm a firm believer of the refiling. And out of the 30 cases that were refiled last year, by the way, right, after RFE. And all those cases that were filed after denials, and were like a bunch of maybe 5 or 6 cases because we just don't get a lot of denials. 28 out of the 30 got approved. The 29th got the RFE and then got approved. So 29 out of the 30. And the 1 out of the 30 got the second denial. Someone is really unlucky, what can I say? And out of those 6 that were refiled after the denial, 5 or 6, I can't remember, they all got approved. The statistics is right here. All right, guys, so smash the like button, follow me on YouTube, follow me on Instagram and TikTok. Also ask me questions, comment. My name is Stanislav Shamayev, a lawyer of the future. Your future begins here. Good luck.